Hi and welcome back to Republic TV. Last week I was up in Scotland and I had the opportunity to meet up with Adam Tomkins, who is a supporter of Republic, as well as being the John Miller Professor of Constitutional Law at the University of Glasgow. I started by asking him about the argument from monarchists that the whole issue doesn't matter simply because the monarch has no real power.
I think it's one of the greatest myths that the monarchy has put forward and established over the course of the last, I guess, century or so, really. I mean, it's just patently false. The monarchy has immense constitutional power. Only the Queen can appoint the Prime Minister. Only the Queen can dismiss government ministers or dismiss all the government. Only the Queen can give the royal assent, which is necessary for any bill which has been passed by the House of Commons and the House of Lords to come into legal force as an act of Parliament. And only the Queen can dissolve Parliament, which is the constitutional device that triggers a general election. The people can't do that. The House of Commons can't do that. The Speaker of the House of Commons can't do that. Only the Queen can exercise these powers. Now, the Constitutional Convention is that the Queen will act only and always on ministerial or prime ministerial advice. But were the Queen not to act on advice, and there have been plenty of instances in the 20th century when that was the situation, no one can seek judicial review of any of this. There's no parliamentary investigation of any of it. So these are powers which are held in check by nothing more than habits and customs and goodwill, and constitutionally that's not good enough.
And are there any examples that you can give? You say there's a few occasions in the 20th century. Are there any examples you can give where the Queen herself, or perhaps one of her predecessors, has acted?
Well, yeah, for sure. I mean, I'll give you a couple of examples. In the early 20th century, the greatest constitutional crisis of the 20th century was the failure of the Liberal government of 1906 to get its budget through, Lloyd George's famous People's Budget of 1909. And the reason why that developed into a constitutional crisis was because of the unwillingness of the House of Lords to accede to the democratic will of the House of Commons. And Asquith's, he was the Prime Minister, his solution was that the King should simply appoint more Liberal peers to end the Conservative dominance of the House of Lords. And the King said, well, I'll do that, but only if you go to the country first and we have a general election, which of course Asquith didn't particularly want. So there's an example of a King refusing to do something that he's required by his Prime Minister to do because the King essentially doesn't want to do it. Much later on in the century, in the present Queen's reign, there was significant controversy over the choice of who should be the leader of the Conservative Party and the Prime Minister, both in 1957 and in 1963. The result of that was that the Conservative Party changed its rules so that it would be clear that the House of Windsor would no longer have such a big stake in it. But twice during the present Queen's reign, the Queen has effectively chosen the Prime Minister.
Could you say a bit about the royal prerogative powers and you know how those are used? And obviously there's been some fairly high-profile arguments about power to go to war, the power to sign treaties and so on. Perhaps you could expand on that and say how those are used by the government.
For sure. I mean, the royal prerogative is a hugely important part of our constitutional law. I mean, hugely important part of our constitutional law. And the royal prerogative just means that the power that the law recognises as vesting in the Crown. And in former times, all of that power would have been exercised by the King or Queen, him or herself. And then some of that power was shifted to courtiers and some of that power was shifted to ministers. But it's still the case that there are huge amounts of our Constitution that are governed not by Act of Parliament, not by the House of Commons, not by anything which touches upon the people or the people's elected representatives, but which is governed exclusively by the royal prerogative. Now, there are some prerogative powers which even now can only be exercised by the Queen herself, such as the ones we've already talked about: dissolution of Parliament, appointment of Prime Minister, royal assent to legislation, and so on. But most prerogative powers are now not exercised by the Queen herself, but by the Prime Minister and by other ministers in the government. The problem here is that these prerogative powers are ill-defined. It's difficult to get them judicially reviewed, to get their exercise judicially reviewed, and it's difficult to get Parliament to scrutinise the way in which these powers are exercised. Why? Because they are covered and shrouded and protected in the mystique of the Crown. The ministers will come to Parliament and say this is an exercise of the royal prerogative, as if it's got something to do with some notion of top-down government rather than government in the people's name and in the public interest. And there are examples from when Mrs. Thatcher was Prime Minister, when John Major was Prime Minister, and when Tony Blair was Prime Minister, which I think speak quite clearly to this. The Thatcher example is the decision she took in 1984 to ban trade unions from GCHQ, which is part of the Secret Service, part of the Security Service. Controlling the terms and conditions of employment in the civil service is a prerogative. It's a prerogative power. There's no statute that governs it. It's a prerogative power. And she just unilaterally said one day, if you're a civil servant and you work for GCHQ, you can't be in or join a trade union or form a trade union. It was actually the first decision that the Labour government overturned in 1987 when it was when it came into power. And Robin Cook made that decision on the first day of
again with the prerogative.
Yeah, again under the prerogative, just reversing it. And this was a pretty controversial decision. It was judicially reviewed. It went all the way to the highest court in the country, which is the House of Lords, and the House of Lords unanimously held that it couldn't be judicially reviewed because she was acting under the prerogative rather than acting under a statutory power. When John Major was Prime Minister, the big scandal was over the Scott inquiry on arms to Iraq and the way in which the government had used the prerogative to keep sensitive information out of criminal courts. The prosecutions collapsed because government ministers changed their evidence on the stand. This was the late Alan Clark MP. But if the government had had its way, then executives of companies, of export companies such as Matrix Churchill would have been sentenced to up to 7 years imprisonment for trading with Saddam Hussein's Iraq. The reason why they were trading with Saddam Hussein's Iraq was because we didn't like Iraq much, we didn't like Iran even more, and we were trying to prop up the regime in Iraq through the offices of MI5 and MI6, and these guys who were in the dock were helping MI5 and MI6. And all of this is governed by prerogative, and the government said, well, you can't have it, you're not going to allow this information to be released into open court using a prerogative power called public interest immunity. It used to be called Crown privilege, which is actually a better name for it, Crown privilege. That led to a 3.5-year major judicial inquiry, the Scott inquiry, reported in 1996, which again it was, I think, one of the contributory factors that led to the demise of the Major government in the 1997 general election. And the famous example, probably the most important example of all of these, really, and most shocking and outrageous example of all of these was Blair's decision as Prime Minister in 2003 to go into what was certainly an illegal war in Iraq on what was certainly a false prospectus. The Prime Minister has the power to wage war. Why does the Prime Minister have the power to wage war? Because it is a royal prerogative power. There is no act of Parliament. The British people and its elected representatives in Parliament have never conferred this power on the government. It's a royal prerogative power that comes directly from the Crown. Now, clearly it's the case that the government needs to have this power, right? But clearly, equally, it's the case that we, the people, and through our elected representatives in Parliament and in the House of Commons, need to determine clearly in statute what the limits of that power are, rather than the Prime Minister just waving a sort of prerogative in the air as if it's some sort of magic wand that says, I can determine the conditions on which we fight war, where we fight war, when we fight war, how many troops. None of this is subject to any parliamentary scrutiny at all. All of this takes place completely out with the democratic framework of the British Constitution, because the Prime Minister has in his pocket something called the royal prerogative that he can just use.
And I mean, do you think that there's a link really between why pretty much every government, or certainly every Prime Minister, has always been pro-monarchy? Because they get into office
Absolutely.
and they see what it does.
Absolutely. It's not in the government's interest for the monarchy to be reformed, because the government, every government, Tory or Labour, takes an enormous amount of power from the monarchy, from the Crown, power which it can wield in the face of parliamentary opposition, despite parliamentary opposition, and power which still largely is not reviewable in court. No one could go to court and say that the Prime Minister's exercise of the prerogative to wage war was illegal, because no court will hear a case like that.
And what about the Privy Council? How does that work? Is that another mechanism for the government to use royal prerogatives? I mean, is that an important issue for the Republic campaign?
Indeed. Well, one of the principal functions of the Privy Council now, well, there are many functions of the Privy Council. One of the most disturbing functions of the Privy Council now is in colonial governance. I mean, people talk about the British Empire in the past tense. Britain still has an empire. We still have 10 overseas dependencies. And much of the legislation, even the constitutional legislation of these overseas dependencies, and around the world more than 30,000 people live in these places. They include Gibraltar and Bermuda. And much of the legislation, including the constitutional legislation of these places, is made in secret by Her Majesty in Council. That's the Privy Council in London. And there are a couple of examples recently of most horrendous legislation being made. The whole of the constitution of the Turks and Caicos Islands was suspended like that because of corruption in the Turks and Caicos Islands, in secret by Her Majesty in Council this year, 2009. And in 2004, I think it was, the government decided that the British Indian Ocean Territory, which is where Diego Garcia is, which is an American Air Force base used for rendition flights and probably worse in the recent war on terror, should remain wholly depopulated. And Diego Garcia, the whole of the Chagos Islands, what's known as the British Indian Ocean Territory, or BIOT, was wanted by the Americans in the 1960s and 70s as an Air Force base. There were somewhere between 1,500 and 3,000 native islanders, the Chagosians, living on those islands, and they were depopulated. The islands were simply depopulated by the British, acting under the authority of the royal prerogative by Her Majesty in Council. And they've never been allowed back. Many of them were just simply left to rot in the slums of Port Louis and Mauritius. And it's an absolutely outrageous story. And the House of Lords, again our highest court, by the narrowest of majorities, in a very important constitutional case last year, held that the Crown was right, to, or the Crown had the right to do what it had done. And again, you know, it may very well be that if the government was acting under statute rather than under the prerogative, it would make the same sorts of decisions. But at least it would be, one, fully judicially reviewable, and two, in the open, in the democratic eye, fully subject to the rigours of parliamentary scrutiny.
And